Our next case is Wallace versus Smart. Good morning. This is a 15-minute mini oral argument on the application. Mr. Payne, you know the drill. You just saw it.
Good morning again, Justices. For the record, my name is Matthew Payne, and this time I'm here representing Ms. Parie Wallace regarding essentially the same issues. I do want to, in my free fire, just point out a couple of things that I forgot to mention or that were just raised on rebuttal. First, I am acutely aware of the trend in appellate authority giving providers, I don't want to call it more standing, but I don't know, somehow more solidified standing or better or independent standing to the patient's entitlement to benefits. But those cases are still at this point limited to the rescission context, and they haven't hit this court yet. There are going to be millions, tens, hundreds of millions of dollars at issue here based on what this court decides, even if that trend continues. So this is a very significant issue. And I guess ultimately, even if it goes the other way, I guess to be very plain, I think any ruling from this court that does not acknowledge the dual nature of the patient's right along with the provider, even if the provider has assigned it away to a factoring company, any decision that eliminates that dual or multiplicity of rights is necessarily going to harm the people the No-Fault Act was intended to protect without giving any real benefit or any justifiable benefit to the insurance companies. And ultimately, it may not even affect the providers that much more other than paying their own attorney fees, because what it will do to a certainty is every single provider now is simply going to file. And this isn't, a couple of extra, litigation files per accident. You could have one data service and you've got the medical transportation, the surgeon, the surgical facility, the provider that gave the DME, the anesthesiologist. They're all going to have to file their own separate claims for that one surgery. And it just doesn't make sense. We haven't had any issues in the past dealing with this, with a dual nature or a multiplicity nature of these claims.
Isn't the easiest way to solve this just in the contract when the assignment takes place to reserve the right to bring suit? I mean, you don't have to divest all of the rights. You can contract however you want.
Well, so to be very clear, yes, I think at this point, now that the legislature has changed the outcome of covenant by providing the direct statutory cause of action, before that change in June 11, 2019, the providers were required. That was one of the arguments that I was talking about in the post-covenant fallout. They're saying, well, they didn't assign the right to sue, so you can't be here. Only one person could, according to the question, own the right to sue. And that was the problem. If the assignment didn't transfer that right, then the provider still had no standing. Yes, I agree that with the change in the law that we've seen recently, not just the legislative amendments, but how they've been interpreted so far in appellate precedent, I do think that we're getting a little bit away from that. But again, the duplicative nature of these claims has never been a problem before. There are vehicles to protect the only legitimate interest the insurance companies have raised, whether it's joinder, or there are plenty of practical outlets as well. I settle these cases still for C-Spine to this day, where the factoring company signs the release as well, or there's a defendant indemnify clause saying if somebody else comes after us, you have to pay for these charges. There are plenty of ways to do it without litigation. Any ruling from this court that says only the assignee can file is going to cause a huge skyrocket in really unnecessary PIP litigation, because these providers are going to be forced to sue when they would otherwise rely on the patient's attorney to collect.
Unless the assignor drafts a contract that says that they retain those rights. I mean, I keep going back to that. I guess I'm not understanding the practical answer that you're giving us.
So, I guess I'm a little bit confused by the question then. If you don't assign the right to collect the benefits, what would be assigned at all?
You can, and you can retain them. C-Spine could have said, the factoring company is doing all of these things, and we also have the right to bring suit.
And maybe to tag on that, C-Spine could do that, but could Ms. Wallace have done that when she's receiving medical care? Could she have drafted the assignment such as to retain her right to sue, despite assigning the right to collect?
Well, but Justice Kavanaugh, you were just talking about the case law in other contexts where only the assignor has the right. So I guess why would that be different here? If people could have done it before, why hasn't it been done? And ultimately, I think what I'm hearing you, Chief Justice, is essentially assigning the beneficial right only. I'm giving you the right to the payment, and, well, I guess not just the beneficial right, but also the opportunity to sue for it. But I think that's really what, what would be the point of the assignment at all? The patient, Ms. Wallace, needs to be able to protect her right? So I guess the assignment would be, you can sue, but so can I. And I guess if that could exist, and it didn't, and maybe I should have thought about that more based on the legislative changes and the subsequent case law, but that didn't exist before, and it didn't precipitate this case, because at that point, the assignment had to transfer all rights, or there would be none.
So I'm feeling like you're arguing the opposite. So, I mean, what you're here saying that both should be able to file suit.
Yes.
Right? That both Ms. Wallace and the assignee.
Regardless of what the assignment says, but I would acknowledge, to your point, if there is a way to write that agreement where the provider has all of the rights and the patient has all of the rights, let us know how to do that. Because I guarantee you I'm going to get arguments that say you can't. Right? So as long as this court says there is language, here it is. Here's the magic language that says both parties can sue, I'm entirely happy with that.
Well, you're saying that the statutes already say that.
Yes, I do. Yes.
So there's a way to write it.
I'm saying the statutes allow that even in the context of the assignments that are at issue in this case and in C-Spine. Based on the party who made a contract for another may sue in his own name without joining that party. If these assignments don't give the right to both parties, then I just need to know what language does.
Counsel, why in this particular case didn't the providers file lawsuits or try to intervene?
Specifically because of what I was talking about regarding, I do a lot of provider and patient work. And I get, 30 cases a day or 30 cases a month from a particular provider, right? If one of those cases, and I'm not the only one that represents that provider, they send another 30 to another firm. But if I'm already representing that patient, had nothing to do with why they ended up at that provider, but if that provider knows that they would have sent it to me, or rather than sending it to another firm, we're already doing the work. We already have that claim. So there's no reason to send it elsewhere. I don't know if that...
That's fine, thank you. Yeah.
And does the provider still have a cause of action to pursue against the insured, against the victim?
That's a tricky question that I'm all too familiar with as well. Yes, of course. The simple answer is they have to. Having incurred the charge is an element of a no-fault claim. So the provider, the insurance company can't even be liable unless the patient is liable to the provider. And that's what we're talking about in the context of this case, where it was a patient assigning her right away. Sometimes those providers sit on their hands. And in this particular case, because I know the trial lawyer and I know exactly what actually happened here, is that they didn't want to sue. They were comfortable with her representation. She's dealt with them before. They were fine with that. They didn't need to sue. They didn't want to incur the cost and go through the discovery and everything like that. When they don't, sometimes the providers are not that astute, right? Sometimes it's just an error. Sometimes they get an assignment and they never send it out to a lawyer for litigation. And that's another part of my problem with this. These insurance companies never raised this issue within a year. They've known the whole time that these assignments exist. They wait until a year after the assignment was executed and all the treatment is done, and then they say, oh, but wait, you're not the right party. I knew this 2 years ago, but I'm only going to raise it now because the real party doesn't have any rights anymore. So aside from my estimation of the intent here, regardless of that, to get back to the question, some providers will sue because they're not comfortable relying on the patient or the patient's attorney, and they need that ability because I see all too often some of these patients just walking away. They don't show up for depositions, their cases get dismissed. There's nothing we can do about it. That provider needs the ability to go directly and say, okay, now it's my obligation. Not only do I have to prove reasonable necessity of my treatment and the reasonableness of the rates or comporting with the fee schedule or whatever you want to say, but now they also have to prove accidental bodily injury. This is not an easy feat without a patient involved in the case. So they have to be able to protect their interests and go through all of those hoops to be able to get paid, because they can't always rely on patients and their attorneys to collect for them, which is why they will always need assignments. I've got plenty more time, but unless there are any questions, I'll just reserve it for a rebuttal. Thank you.
Thank you.
Good morning, Your Honors. Nathan Sherbarth on behalf of Suburban Mobility Authority for Regional Transit. I know that this has been discussed extensively, so I will waive my free fire zone. I'm happy to answer questions. But I wanted to talk about something that I think that Brother Counsel just raised, which was this idea that providers need to be able to protect their rights because the injured party may not be adequately pursuing their own litigation or something to that effect. Well, that's why they get assignments, and that's what McCosta does. McCosta cuts off that privity, and so the providers are no longer bound by what happens in the underlying patient's case. But they can't have their cake and eat it too. They can't say, on the one hand, I need this assignment so that I can pursue my own rights. But then they get to ignore the one-year back rule and say, oh, well, we've always had the right to bring, either of us has always had the right to bring this claim. I mean, then the assignment's meaningless, but then privity's not cut off. So I can't say that I particularly follow that, but ultimately, Chief Justice, your argument about your question about the freedom of contract, I think is crucial here. Freedom of contract is sacrosanct. They make these agreements, and they choose the language they want to put in it. And in the C-Spine Ortho, in this case, put in the assignment to Ms. Wallace, with Ms. Wallace, I hereby assign, transfer, and convey to C-Spine Ortho all of my rights, title, and interest in and to medical expense reimbursement in whatever form, including but not limited to any automobile liability medical expense payments or other health benefits, indemnification, and/or agreement otherwise payable to me. I don't think it can be any clearer than that. She assigned all of her rights to C-Spine.
Did she have bargaining power?
She
to
does.
be able to do that? I mean, I understand that maybe sophisticated providers and even factoring companies may be able to do that, but as you're getting a ride in an ambulance or you're, going in for surgery and that, and you are assigned as an injured person needing care, the freedom of contract, is that truly in existence in a case where it's the injured person assigning away their rights to the person that is going to provide them needed care?
I think you still do, because I mean, in this case in particular, you're talking about medical transport providers. You're talking about these providers that they go and see after the fact. Sure, in some circumstances, I could see if you're in the hospital and you're in acute distress, maybe the bargaining power is not particularly equal. But I think it's a dangerous idea to say that all of these assignments then would potentially be invalidated because of inequality of lack of bargaining power, because
Well, maybe you're not invalidating the assignments,
Right.
but saying that it doesn't actually divest you of standing, but that you can't be subject, you as a defendant, to multiplicity of judgments, right? That's where the real party in interest comes in to make sure that you are only liable to the real party in interest. So,
Correct.
yeah, in the ambulance ride, you're assigning away what you have to. It's not saying that you can't bring suit, but like if you are not the one who has the obligation, then you better make sure that that judgment actually gets entered in name of the real party in judgment.
Yeah,
Or real party in interest.
I think that's fair. I think that's fair. But in this case, the issue is very simple. It's these providers chose to take these assignments. They chose to execute these assignments. They had no need to. This is post-reform. They have independent cause of action. I don't know why they keep doing it other than to cut off privity. I think that's the real question. Why do they need these assignments if they have their own statutory cause of action under 3112? I'm not sure, but they keep taking them. And so they have to see some benefit in their, because they have standing to bring the claim before taking this assignment. But they can't take this assignment and then say, well, actually, Ms. Wallace still also has standing to bring this claim when she's assigned all of her rights.
Well, Ms. Wallace may have other claims in her lawsuit, right?
That's correct.
That aren't just C-spine, that are ongoing benefits that maybe aren't covered by an assignment or that sort of thing. So she obviously would retain standing in that regard,
Oh,
just not
absolutely.
with respect to the right to collect claims that she has assigned away.
I completely agree, Your Honor. She does not retain standing as to the claim she has assigned away. And I think then this brings us to the other issue in this particular fact pattern, which is these revocations. What is the effect of these revocations? Again, freedom of contract is sacrosanct. I'm not saying you can't take a revocation. Brother counsel has talked about counter assignments versus revocations. I think whatever you want to call them, you can make a new contract. An assignment cannot be conditional. I think there's strong case law that says when you make the assignment, it can't be conditional. But sure, if you've made an assignment, you could make a counter assignment. You could revoke that assignment later if the agreement is subject to consideration. But what is the effect of that revocation? And I think that this is where they're trying to have their cake and eat it too. They want to avoid 3145. So they knew about these claims. They executed these assignments. After they executed these assignments, SMART sent them denial letters, sent them to the providers because they were the real parties in interest, because they had these assignments. They then sat on it for a year. 3145 protects those providers because they have to have notice of this loss, or a notice of the denial for the 1 year back to start running. They did, and they sat on it. They sat on their hands. That's their choice. Whether they thought that Ms. Wallace may have done a good job of pursuing her own case has nothing to do with whether she had standing to assert those claims. And they knew that they had these claims. They knew
So
that
the
they needed to
insurer
bring
knew
these.
also that the assignments existed before suit was filed,
Correct.
right? And didn't raise this issue, the
That's correct.
dismissal for lack of standing or real party in interest until after the year had expired.
That's true. That's true. I
So
think it cuts both
everybody's
ways. I think
monkeying around the 1 year.
right. But the point of the 1 year back rule is, to prevent stale claims. It's a limit on damages because you don't want to have situations where these claims can be brought years after the fact. And what does this do? They're playing a game of hot potato. It's like, hide the ball. Where's this claim going? And then, 3 years later, they say, oh, wait, actually, she now has the claim. But the point of it is, you got a year, you bring it or you don't. They knew about these claims. They knew that they knew that they were denied, and they sat on it. They sat on their rights. The idea that the only purpose of the No Fault Act, or the only legitimate interest in that the providers have here, or that the insurance companies, well, SMART is not an insurance company, but that the payors of benefits have here is to prevent the duplicative nature of claims. It's also to prevent duplicative litigation. If these claims are held by both of these entities, they could theoretically both file suit, and then, what are we supposed to do with that?
Well, if we say the insured can't file suit, you're actually going to be subject to way more suits, right? You're going to be subject to suit by every single provider, as he indicated.
And they do that.
Well, they do.
They do
So
that.
I think multiplicity of suits is sort of out the door, right? I mean,
It's out the door, but at least then if the assignment means that the right has been transferred, that standing has moved to that provider, that provider holds that claim and is the proper party to be suing, as to those benefits. But it's when you have this gray area where they keep moving these claims, we just want certainty here, and they shouldn't be allowed to, on one side of the mouth, say, well, under McCosta, we're not in privity with the injured party, so therefore, we're not subject to whatever malfeasance or nonfeasance they may do in their own suit. But at the same time, we do get to have the benefit of the 1 year back rule with respect to the injured party. We're going to execute this revocation, treat this assignment like it never existed in the first place. And what they really want is a new pro tunc effect to these assignments. They want to pretend like there was no passage of time, and there was. The reality is when they take back that counter assignment or revocation, however it's framed, they have to take the assignee takes what the assignor has to give. And at that point, the assignor, the providers, have a stale claim. That claim is subject to the 1-year back rule. It's stale, they can send it back, but it's a legal nullity. And if you let them contract around that, I think it opens up a whole can of worms to say you can move claims, you can contract in derogation of the statute when the goal is prompt payment and finality.
Can you, could an assignment, would you agree that if an assignment specifically said that the assignor retains the right to bring suit under 3112 or, in the case of Ms. Wallace under the other statute, that's possible?
I think under, the freedom of contract principles, yes. I mean, I think that under...
So it's saying, I'm giving this to you, but I'm actually also retaining it. I mean, it's a different question of whether or not somebody actually wants an assignment that looks like that.
Right.
But is that
exactly.
even possible, saying I'm giving you all these rights, but in fact, I'm also retaining all these rights? Is that
I think
really an
that
assignment?
looks like a conditional assignment to me, and I don't think that's an assignment at all. Because then you're not actually giving them a present right to the beneficial interest. You're talking about, they're retaining this, so it's conditional on, well, you get something, but I also get to keep something.
So there isn't a way under contract principles to actually avoid this issue?
I think under the way our assignment jurisprudence has developed, the answer is no. You either assign it or you don't.
Right.
But I'm not sure, it sounds like Brother Counsel is saying that he thinks that these assignments actually do that.
Well, I think he's sort of rhetorical, saying like, if you can tell me a way to assign something away and keep it, let me know.
Yeah.
Well, no, he's saying that that's what already
That the
exists.
existing
Right.
Yeah.
assignments do that.
Yeah.
And I don't think, and then
It can't
they're
be
legal
both.
nullities. Right.
But, I mean-
You can't have it both ways. You really can't. Either it puts Mecosta in a really difficult position if this, if these assignments actually don't mean anything, but, they can still somehow work around 3145. I'm happy to answer any other questions. I know we've talked about this at length.
I don't see any. Thank you very much.
Thank you.
Very briefly, Justices, I just want to kind of bring this all back to the beginning. And for well over 40 years, we had no issue with the duplicative nature of these claims. This court interpreted the law differently, and we had a period of time before the legislature went back to that 40 years of time. And that's really what we're talking about, sort of a snapshot in time. But now we've sort of changed everything in that assignments are essentially, as Justice Kavanaugh mentioned, this is a conditioned precedent to even getting treatment at this point for no fault, because this is what providers understand they have to do to protect their own interests. They can't always rely on the patient's attorney. They need the ability to pursue their own interests. And contrary to what Brother Counsel said, this is not providers attempting to circumvent the year back rule under 3145. This is providers trying to get paid once, not twice, just the one time. This issue only comes up because the insurance companies are using 3145 as a sword instead of a shield. They were well aware of these claims the entire time. They were well aware of the assignments the entire time. They refused to pay timely. They sat on their hands.
I'm sorry, to your point, no, the provider didn't pursue this.
It's exactly my point. But now the problem is the patient is liable to the provider in contract, and she has no ability to collect it from the insurance company when everyone.
But she assigned everything to the provider. The provider has recourse, right? They get to go after the insurance company for payment.
Could, yes.
And they chose not to.
Because they were adequately protected by the plaintiff and her attorney in this particular case, which reduced the need to file all of these multiplicative lawsuits on the same claim. They were content getting paid one time through the patient. It wasn't until their rights were evaporated, cut off, terminated by operation of the statute of limitations that this even was raised as an issue in the trial court. And that's really my point here. There was never any attempt to get duplicative payment. They were trying to get paid once. And this is
But they
just,
didn't pursue their options to get paid that one time.
they were aware of the litigation, they were comfortable with the pursuit that was already happening. This case is still pending. They're still hoping to get paid.
They were relying on how it's always worked.
Exactly. When they have confidence in the patient's attorney and that patient is actively involved in the litigation, doing her obligation, we know we're plaintiffs, we have the burden of proof here. We can't just say, hey, pay it. So we got to come in and prove our case, right? That's what they were doing. And it wasn't until that year expired that this even became an issue.
So like Ms. Wallace incurs the cost for treatment from the medical provider, right? Has assigned it to them. She has no control over whether or not the medical provider actually pursues that timely in order to get paid, right? But that assignment, and correct me, like, it doesn't sort of work back to her protection either, right? I mean, when you're assigning your claim to C-Spine or whomever, they still have the ability, if they don't pursue a claim or they get knocked out or whatever this may be out of a lawsuit, they can still pursue Ms. Wallace for that bill.
I can tell you in practical application that does not happen.
It doesn't happen. Why doesn't it?
Because in
happen?
every single instance, the patient signs a release with the provider. Or in every single instance when this happens, either the provider gets paid through the patient's case and that check comes with full and final. This is a contract. My client, if I'm representing Parie Wallace.
No, I mean before suit. So if they've assigned, you know, she gets treatment, she gets a ride in the ambulance on day one, and she's assigned that claim, if the provider doesn't pursue the insurer, and because she's assigned it, she can't pursue, that bill doesn't get paid, does the provider release Ms. Wallace's liability to it?
No. So there is some case law that we could discuss, but we don't have the time, about the exclusive remedy nature of the No Fault Act, right? But without getting into that again, I really just, I want to answer the question, yes, she has to be liable because that's an element of the No Fault Act. She has to have incurred the charge. So that's incurred between the provider and the patient regardless of any assignment. So yes, she needs the ability to protect herself. Even if she gave away the right to the provider, that provider may not end up suing. And you're right, she may be out of luck. Just because she signed 1 out of 10 intake forms, or at the end of her treatment, she happened to sign something she more likely than not didn't even read.
So,
now she has to pay her own medical bills that would have been covered otherwise.
So the provider doesn't pursue their rights under the assignment, and they just wait, and then you know, the time passes, and then they go back to the patient and say, you owe us $100,000.
I'm not aware of that ever happening either, honestly. Even if it was the provider's own indolence that precipitated its inability to collect, they still don't sue the patients.
Just as a practical reality.
Why would they
They
go to
could.
that facility if the one across the street isn't going to sue them if they don't do their job, right? So right, it's if you have an option to go to, there's not a lot of PIP providers out there because it is a minefield to try to navigate. But the ones that are out there are requiring assignments. If there's another one, if one of them is suing their patients because they didn't do their own job and pursue their own rights, why would any patients go to that facility?
Well,
Why would they?
it's in circumstances where the patient has a choice to go there, right? As opposed to being taken to a hospital following a catastrophic accident, getting an ambulance. They don't have a choice of who gets sent and whether they get an assignment and whether or not they collect against their patient rather than pursue the insurance, right?
Right.
You came up on rebuttal and you said, for 40 years the system worked. And then this court changed the rules. As covenant, I wrote it. It was 7-0. And somehow, some way, a footnote slipped in about assignments, and I'll take full responsibility. But then the legislature changed it, and you admitted that. And the legislature went back to where we were. And then your next line was, but now we have these assignments everywhere. If we reverse in C-Spine and affirm in Wallace, does that not go back to where it was with the legislature fixing it, and then everybody can go back to the way it was with statutes and contract principles in place as they've always been interpreted?
Hypothetically, it would, but the 3112 issue, again, only has been applied to the rescission context in the Mota Peguero case. I guess my point is there are a lot of other reasons an injured person, a natural person, could be not entitled to benefits, right? Other than rescission of the applicable policy. The provider needs it. So a really great example would be assigned claims, because assigned claims claimants are required to actively participate in any sort of investigation, right? So if that particular claimant does not fulfill its obligations, and this has not been decided by any appellate court at all in this state, whether the provider still has a right now based on the 3112 direct statutory cause of action. So the assignments still apply in cases where the patient, for some reason, is ineligible. For example, fraud in the inducement, or I would extrapolate as well into the assigned claims context where they refuse to participate with the insurance company or the assigned claims plan's attempt to investigate.
But none of those issues are implicated here in either of these cases.
But that's also, I guess, sort of my point.
And those problems always existed even before covenant.
Yes. I mean, the entitlement to benefits is always an issue, but assignments solidify the provider's rights in a way that has never happened before. And now, despite the new readings in the appellate courts regarding 3112, there are still protections that need to be addressed.
So what you're saying is even if we reverse C-spine and affirm in Wallace, that decision is not going to change the industry practice of still requiring assignments?
I don't want to speculate on that, but I would tell my clients that what they need to do is get the assignment and then make sure to decide whether to sue timely. That's it. So, and that's
Your client C-spine?
all of my provider clients. Any of my
Provider clients, but not insureds, not individual insureds. It doesn't, they don't benefit, right? If the provider didn't require assignments, great. They have standing to sue, provider has standing to sue. It goes back to the way it was. Everybody gets joined so that there's only one judgment, right? If the assignments were just to go away, but I don't think that providers are going to just say, okay, we don't need assignments anymore.
That's exactly my point, because they offer protections outside of what they have under the statute by itself.
Protections they never considered before covenant.
Protections they really never considered before a lot of these arguments were being raised in the first place. So the collateral estoppel, for example, if we want to go back to Macosta.
So aren't you telling me that the lawyers are creating the problem? If we just go back to pre-covenant, which is what the legislature tried to do. By the way, covenant stood for, hey, you don't have a direct cause of action. And now the legislature said, you're right, let's give them a direct cause of action. Why doesn't that take us back to square one? And shouldn't lawyers learn, maybe it's not the best thing to be pursuing assignments when we have our own direct cause of action?
One very specific answer or example of that is the Macosta case. And then Redburn, which was unpublished, but the same circumstance but backwards. There was in Redburn, the patient sued, but really had no reason to even bother. Didn't really have much left after all of the assignments. All of the providers had all of the claims, didn't really have any interest in it. And that case I think that one went to trial. And they didn't meet the burden. But in Macosta, that actually came to this court, it was the same issue in reverse. The patient's separate case, he really had no purpose, no issue, no reason to pursue these bills. Macosta County Medical Center had hundreds of thousands of dollars invested in the outcome of that litigation. They have very different fiscal reasons to pursue that claim zealously. And the reason, this all goes back to, again, the assigned claims context, and what providers cannot do and stay in business is rely on the patient to effectively pursue its rights. They can, they do. In this case, that's what was happening. We eliminated a number of unnecessary lawsuits because Ms. Wallace and her attorney were actively and well seeking the benefits at issue. When that doesn't happen, the provider needs its own rights. And it's not just the right to sue, it is also the destruction of privity in that context. Because when that patient has no claims left. Let's say there's no work loss, no household services, it's all medical entirely. And she had signed away all of her rights. What purpose would she have? Or let's say all she has is a fraudulent household services claim and she goes to trial. And the jury says, you get nothing. There wasn't even an injury in this case. But she didn't really have the reason to advocate the way that the provider did, who, as it happens to matter of fact, wouldn't have been involved in the fraud in the first place either. So they need their independent rights premised on assignment in addition to the right to sue under 3112.
Okay. Thank you very much. Case will be submitted.
Thank you.